The day. This panel will focus on the invisible injuries of HIV/AIDS and how it affects the areas of domestic violence, sex work, and HIV testing. We are fortunate to have our esteemed moderator, Professor Kim Blankenship. She was given an excellent introduction before our last panel. So without further ado, I will turn it over to Professor Blankenship.
Okay, thank you. I'm going to do the same thing I did before, and that is introduce our speakers, each one in turn, and try to keep track of the time to give ourselves at least a few minutes after the talks for questions from the audience. So our first speaker on this panel is Jane Stoever. She's the director of the Domestic Violence Clinic at American University, Washington College of Law, and previously taught in Georgetown University Law Center's Domestic Violence Clinic as a Women's Law and Public Policy Fellow. She has also served as a judicial clerk and worked at legal aid offices and shelters for teenage girls and homeless families. One of her areas of research interest is in the intersection of HIV/AIDS and domestic violence, as we will see in her talk today entitled The Presence of HIV/AIDS in the Domestic Violence Context.
Hi, thanks so much for inviting me to speak here. I'm really just very delighted to be here. My presentation today is going to focus on the intersection of HIV/AIDS and intimate partner violence. And in my work, I bring together the worlds of law and of public health, and also the experiences of survivors of domestic violence and their stories, to show the importance of recognizing and responding to HIV-related domestic violence. So today I want to start by describing the problem and then examine how the courtroom environment and issues of stigma prevent people from testifying about HIV-related aspects of violence. Our legal system is therefore not responding to the problem, and this affects the protection that individuals receive. And I'll conclude by offering some of the advancements that could occur with greater awareness of this intersection. So in terms of the problem, domestic violence is really about power and control. And in an abusive relationship, the use of HIV status can be a really effective way to exercise control. The presence of HIV or AIDS in domestic violence can change how someone experiences abuse. HIV/AIDS may influence the nature of violent acts and the type of power and control exerted, and it can transform the effect of violence by elevating the level of danger and the consequences of acts. So let me give you an example from my experience teaching in a domestic violence clinic. One woman described how her boyfriend had flushed all of her HIV medication down the toilet. As he did this, he said, "You're going to die anyways." This is somebody in a relationship who had previously been assaulted in ways that are more recognizable in the world in terms of being punched and physical assaults of that nature. But it was this incident that really hurt her most deeply and was the thing that caused her to come to the Domestic Violence Intake Center and to seek help. And there are other forms of medical interference, in addition to this example that I just gave. Had clients who've been locked inside of their homes, unable to allow healthcare workers into the home, unable to actually go out to seek healthcare. Other clients have described their partners refusing to be tested for HIV, but actually taking and ingesting their own HIV medication. Other categories outside of medical interference, clients have described their inability to insist on condom use because of the power dynamics of violence in the relationship, which has then resulted in their HIV infection. The public health literature refers to this as the inability to negotiate condom use. But in domestic violence relationships, the term negotiation really distorts reality because you're not on an equal playing field, and that negotiation really is often impossible. And this is a pretty impossible situation that people face in terms of examining either immediate physical safety consequences of insisting on condom use or long-term health consequences. Other categories of HIV-related violence include escalated violence following partner notification of the abused partner's positive HIV status, or abusive partners threatening to reveal a person's status, having this piece of knowledge and threatening to reveal this to others in the community as a way to exert power over another person. also seen survivors being forced into sex work and drug use, which increases the risk of infection. And then HIV infection resulting from sexual assault and even from the intentional infection of another with HIV. So these cases are deeply troubling. They're troubling to hear these examples, and my clinic students are also deeply troubled by these cases. And in terms of looking at the legal system's lack of responsiveness. So we see this problem in clients' lives. And the public health field has done tremendous work in terms of actually recognizing this as a problem and doing studies on this intersection. But courts, laws, and community response systems are not currently addressing HIV-related violence or acknowledging really the complexities of domestic violence, and instead respond to an oversimplified definition of domestic violence. So for me, the question becomes, if the frame shifted and if HIV/AIDS was seen as relevant to someone's experience of domestic violence, how would the legal system's response improve? Some of the ways that the legal system can better address this complex problem include procedural mechanisms to allow domestic violence courtrooms to become places where litigants can reveal socially stigmatizing, otherwise confidential information without fear of negative repercussions. Substantive law changes, including expanded grounds for seeking protection orders and awarding relief, and better tailored remedies. And then finally, looking outside of the courtroom, our community-organized efforts to combat domestic violence are an integral part of the response. So with an awareness of HIV-related violence, advocacy response systems can be better designed to fit people's actual lived experiences of violence. But before addressing these three areas, I want to look shortly at the current state of the law, why this problem is not currently revealed, and why that matters. The state's response to domestic violence and laws on domestic violence are very, very recent. Early domestic violence laws developed out of the consciousness-raising groups of the women's movement of the 1970s. The law in this area is really still developing. It's only been since the early 90s that each state even had a domestic violence protection order statute in place. And so we see the law is still developing, and it's really happening at the level of practice and at trial courts. The primary legal tool for addressing domestic violence is the Civil Protection Order. Statutes vary by state, but in general, orders of protection are available to litigants with a qualifying relationship, such as a romantic dating relationship, child in common, or blood relationship, and when a qualifying criminal offense has occurred, such as an assault or a threat to do bodily harm. These are civil cases, civil legal standard, generally a preponderance of the evidence, and the orders include injunctive relief, a wide range of relief, such as orders to not assault, threaten, or abuse the person, to stay away from them, to not contact the petitioner. Courts can order the abusive party to attend counseling and can award child custody and support, visitation, can award property and maintenance and other relief. So this is the system that we're in. This is the most common legal remedy being used. And thinking back to the examples that I provided about HIV-related abuse, the use of HIV status in domestic violence can radically alter the nature of violent acts. But many litigants are understandably reluctant to reveal their or their partner's status to others in the community. Yet this is precisely what domestic violence courts ask of them. Let me give you a sense of what these courts look like. So in domestic violence cases, typically all of the cases on a day's docket are given the same time. And I've practiced in this case area in Kansas City, Chicago, Boston, Washington, D.C., and have seen these examples across jurisdictions where 30 to 40 cases on one judge's docket, everybody's told to arrive at 8:30 in the morning. The judge doesn't take the bench that early. So all these litigants in domestic violence cases gather and assemble in the hallway waiting for the courtroom to open. And then the courtroom opens, everybody files in, and everyone, this massive audience, is present as cases are called, as trials occur, as people testify in front of each other. In some jurisdictions, the dockets are actually organized by petitioner's zip code. So you're guaranteed to be in a courtroom with your neighbors. The domestic violence courtroom is not an anonymous environment where there's little chance of encountering a neighbor or a coworker. In this branch of the court that deals with the most sensitive personal issues, private lives are revealed. At the same time, we're all familiar with the numerous examples of the negative consequences of being publicly identified as HIV positive. Discrimination in housing, employment, education, hate speech, families being ostracized from communities, immigration consequences. So litigants consider how revealing information about HIV-related domestic violence might negatively affect their family members, the opposing party, and themselves. And in the experience of representing clients in drafting the petition, my students come to me. They cup their hands around their mouths and they whisper to me what their client has just revealed to them about HIV-related violence. They say, "What do we do?" And we talk with the client about what they're comfortable with writing in the petition. Clients ask questions about the size of the courtroom, about who will be present. And invariably, in the hallway, they encounter people that they know in the courthouse. And I see them struggle with this innocent, seemingly simple question: what are you here for? Very hard to answer that question. As we go into the courtroom, clients have asked, do I have to tell this in front of the whole neighborhood? The environment of the courtroom and social stigma combine to prevent petitioners from making allegations and from testifying about HIV-related aspects of violence in open court. So I'm motivated by seeing this problem in so many clients' lives, and also by concerns about access to justice and the systemic issues that are keeping these stories out of court and that are preventing litigants from receiving meaningful and effective relief. To the extent that litigants don't feel that they're able to talk about this and the ways in which HIV status is used as part of the violence, they lose the ability to vindicate their rights, and they don't receive as appropriate of relief. Litigants often now make the choice to tell pieces of their story. They've likely experienced multiple forms of violence, and they may be able to go forward on allegations that look more like a stock story of violence. The judge is comfortable with hearing this. The judge is used to hearing stories about physical assaults and about threats to kill. They're able to get an order under those portions of their experiences, but these pieces only tell part of the danger that they face. And often facts about one party's HIV status are integrally related to the physical violence or the threats. And when portions of the incidents involving status are omitted, the context is lost. Sometimes the stories don't really make sense either. So thinking about the example of the woman whose boyfriend flushed her HIV medication down the toilet, her status and the type of medication mattered. This was different than aspirin, Tylenol. With this knowledge of her status and of the type of medication, we know that it's dangerous to miss even one dose. We can see how this is an act of violence against her. Also, without the HIV aspect of litigants' stories, the extent of the harm is often concealed. So think of the example of sexual assault and rape, or of forced drug use resulting in HIV infection. Knowing the effect of the violence could make a difference to the fact finder in understanding the harm. With the opportunity to tell these stories, litigants are able to provide details. This enhances their own credibility, bridges gaps in the judge's experiences, and permits empathic understanding. And for some litigants, disclosing one's full experience also has therapeutic benefits in overcoming trauma. Both the storytelling and having a judge validate their experience. The presence of HIV in domestic violence cases complicates the situation, often to a point where existing resolution procedures and laws are not equipped to address it. If we take the experience of HIV-related domestic violence seriously, and if people heard these stories, I believe that this could lead to advancement in multiple areas. So we now want to turn to those three areas with the procedural mechanisms that acknowledge litigants' concerns about publicizing HIV status, with substantive legal changes, and then third, with further development of community response systems. So with procedural changes, some simple procedural changes and the use of already existing procedural mechanisms could create greater opportunities for reporting experiences of violence and protecting HIV-related information. So first, to address this burden of the mass calendar call, clerks could schedule domestic violence cases at different times throughout the day, even in shifts of people. But this could be done to avoid having this mass audience at the beginning of the day. We do this in other areas of family court. My colleagues ask, well, when will you be in court? When will you be back? I'm like, well, it starts at 8:30, likely there all day. You're not given a time certain to appear as you are in custody, child support cases, and all the other areas in the courtroom, in the courthouse. Domestic violence cases, we have them all start there at the same time in the morning. The suggestion of scheduling might seem really overly simplistic, trivial, bureaucratic, but the fact that scheduling doesn't currently happen is part of the problem that systematically silences the most harmful aspects. Second, given the social costs of making public one's HIV status, in some limited instances on a case-by-case basis, litigants who wish to keep their HIV status private could take measures to protect this information. For example, they may want to move to close the courtroom in select cases, file cases using initials or pseudonyms, or request the court seal portions of records to shield status-related information. HIV and AIDS-related information is already constitutionally and statutorily protected, and an individual's right to privacy regarding his or her condition can be overcome only if there's a strong countervailing interest. So this balancing test could be conducted. You need to have this motion made to do such things. As I mentioned, the idea of taking anything out of the public view, I have concerns in terms of recognizing the importance of the court watch programs for domestic violence advocates, but also the importance of accountability and fairness that's guaranteed, all of the reasons that we traditionally have open courtrooms. And I also don't want to further remove the reality of HIV and AIDS from the public discourse and contribute in any further way to stigma. But I also realize that these stories are not currently being brought into the courtroom at all, and that people are really shaving off entire portions of their experiences to be able to talk about this in court, and feel that survivors shouldn't have to bear the burden of educating the public on their own. So the use of these existing procedural mechanisms in domestic violence court could end up benefiting both parties, both of whom may have strong interests in not having HIV-related information publicized, and it could increase both parties' abilities to be heard. And we see these procedural mechanisms being used all around the courthouse in other kinds of cases. And so cases alleging discrimination based on HIV status filed under DOE. Information is commonly shielded from the public in other areas at a judge's discretion, sometimes as a matter of course, and sometimes at a judge's discretion when you look to juvenile proceedings, adoptions, judicial bypass proceedings, cases involving trusts, trade secrets, business interests, celebrities, wealthy litigants. This happens in a lot of other areas, but not in the domestic violence courts. And with 70 to 90% of domestic violence litigants being pro se, you can start to see why this isn't happening. But asserting privacy interests then becomes a very complex endeavor. And any meaningful option for keeping certain information confidential has to be accessible to pro se litigants at an initial filing stage, in addition to attorneys being made aware that they have these procedural mechanisms and judges actually accepting the use of the procedural mechanisms. So the possibilities here in terms of this procedural area could end up bringing more experiences of HIV-related domestic violence into courts. And recognizing the use of HIV status in domestic violence allows us to see deficiencies in our current legal systems. And this leads to substantive changes. So protection orders are commonly based on specified criminal offenses, the requirement that you have an underlying criminal offense to be able to get this civil relief. And our current laws suppress certain stories in relevant context by making this requirement that you prove something that looks like a physical assault or a threat, and ends up leaving some domestic violence survivors invisible before the law. HIV and AIDS creates new circumstances for the laws of domestic violence. The remedy of the protection order, really created in the 70s, was created without an understanding of HIV. Through the lens of this problem of HIV domestic violence, lawmakers can develop a more complex understanding of domestic violence and further develop grounds for seeking protection orders and awarding relief. For example, medical interference could become a new ground for receiving a protection order. Where frequently, partners will interfere with the medical care that an HIV-positive abuse victim receives by preventing them from attending healthcare appointments or by taking or destroying their medication. Medical interference is especially dangerous to an HIV-positive individual who's following a strict medical regimen, and it's generally harmful to any person. The descriptions of other forms of HIV-related violence could lead to targeted remedial measures. Consider the example of threatening to reveal a person's HIV status to their employer, neighbors, children's school and daycare, and to others as a way to keep someone in a relationship or to coerce them into other behaviors. This is not a recognizable criminal offense, but it is a really powerful way to exert control over another person, and relief could be entered to actually target this particular person's experience of violence. And so by hearing these stories and understanding more of the complexities of domestic violence, this could actually lead to better targeted and tailored remedies being provided in court. Because when individuals are able to explain accurately what has happened and why, then a judge could have even the possibility of tailoring remedies to their experiences of violence and targeting HIV-related violence. So the remedy would address a litigant's particular safety needs. Protection orders are designed to deal with harm that happens in the home, where people often don't have access to protection. And we now know that these orders can be effective in addressing and preventing future violence and addressing the violence that people need protection from. I believe that the harms of HIV-related violence deserve and require protection. The third and final area is to look at services, because not all of the answers can come from the courtroom. While traditionally domestic abuse intervention programs and HIV/AIDS prevention and treatment programs have operated independently of each other, seeing domestic violence and HIV and AIDS as two separate public health issues, the legal and medical fields could work together in interdisciplinary responses. Domestic violence survivors seeking services have often experienced high-level violence, are injured, and need urgent legal and medical responses. And legal and medical fields' responses could complement each other. So far, the medical field has largely failed to screen for domestic violence and to recognize the healthcare implications of abuse, even though research shows that patients will disclose this information when asked. So in a recent nationwide study of approximately 5,000 women, only 7% said that a health professional had ever in their lives asked them about domestic violence or family abuse. And doctors, nurses, medical personnel, they are all in a unique position to recognize domestic violence. And clients talk about, well, it's easier to go to a routine healthcare appointment for that to be acceptable as opposed to going to the courthouse to seek help. So in terms of reasons someone might leave the home, that's often a place where people are able to initially access, or could be able to initially access help and identify problems of domestic violence. Given the high rates of HIV transmission among abuse survivors and their increased problems adhering to medical regimens, the medical sector cannot ignore the health care implications of domestic violence and the ways in which domestic violence complicates the medical response to HIV. And in light of these health issues at stake, similarly, the legal responses also must not continue without attention to medical interventions. And in the past few years, we've seen that with government grants, cities are developing intake centers, having this centralized access point. It's a place where domestic violence survivors can receive initial services out of one location. These centers typically include safety planning advocates and representatives of the civil system and the criminal justice system, so very focused on the legal response, on the courthouse. These now existing centers provide a locus for addressing HIV-related violence to offer both life-saving medical and legal care to survivors of HIV-related domestic violence. A medical presence that provides emergency treatment, clinical care, and health counseling and advice would complement current legal and advocacy services. For example, we know that research shows that domestic violence is a risk factor for HIV infection. So this counseling around this could be provided to make survivors aware of the HIV risk. Another example, someone who is raped can take antiviral medications to prevent HIV infection. This needs to happen immediately, though. There are multiple places and multiple possibilities for coordinating medical and legal interventions, including creating advocacy centers in health clinics and hospitals, placing healthcare professionals in intake centers, informing patient treatment areas there, and making public health and medical professionals part of any coordinated response to domestic violence in a community. And I believe that the inclusion of health services is a natural and important next step in a coordinated community response. So in conclusion, our courts, laws, and advocacy systems have not addressed the occurrence of HIV-related domestic violence, but the health and safety issues demand the development of timely and effective interventions. And my hope is that some of the problems that I've described and recommendations that I make can begin to inspire such development. Thank you.
Okay, our next speaker is Svati Shah, who is a postdoctoral fellow in transnational sexuality studies and also in the women's studies department here at Duke. Before coming here, she was a visiting lecturer at Wellesley College, and her research focuses on migration, sexuality, and political economy in India. Her book on sex work in Mumbai's informal sector will soon come out, and today her talk is entitled Sex Work, Criminalization, and Public Health in India's Informal Sectors.
Am I audible on this thing? Yes? Okay. So I should start by saying I'm not a lawyer. I'm only pretending to be a legal scholar. What I actually am is an anthropologist who, in working on sex work, has had to engage with laws that structure the kind of economic, cultural, and political life of sex workers in India in some very crucial ways. So what I'm going to do today is to talk about some public health interventions, and particularly interventions around HIV prevention and the law in India as they intersect in policies on sex work. And I eventually, I'm going to try to think about these things within the context of the relationship between brothel-based and non-brothel-based sex work in the city of Bombay, which has had, like many cities around the world, a consolidated set of visible red light areas in the heart of the city since at least the late 19th century. Bombay is interesting for us, I think, because to some degrees it is emblematic of cities in the global south. It's growing very fast. It has huge rates of migration. It's a kind of beacon or a barometer for the effects of neoliberal economic policies. And it's also a city where sex work is happening in many different kinds of venues, which is also, I think, again, emblematic. So in this paper, what I'm really doing is discussing some of the contemporary legal and public health context for prostitution in India. And as I said, I'm going to end with some conclusions around the significance of non-brothel-based sex work for the laws and the policies that I'm going to be talking about, largely because non-brothel-based sex work in India is important, and yet it remains largely subsumed within the policy framework that I'll try to outline here. So concerns about prostitution in Bombay by legislators, middle-class reformers, and the media have accompanied the growth and existence of brothel-based prostitution in Bombay since the Contagious Diseases Acts helped to give rise to informally yet clearly demarcated zones for sexual commerce within the city at the turn of the 20th century. You'll recall the Contagious Diseases Acts were passed in the UK in the 1860s and then were passed in the colonies subsequently at the very end of the 19th century, and were basically inspired by fears of too much venereal disease among in the military, and led to many different kinds of interventions, mainly targeting sex workers, including mandatory health checkups and lock hospitals and things like this. With the rise of anti-trafficking discourses at the time, which framed injunctions against prostitution in terms of white slavery, these concerns about prostitution in Bombay emphasized attempts to rescue white female sex workers who were all presumed to be from abroad, from local brothels. Historian Ashwini Tambe describes the effects of the emphasis on cross-border trafficking in this first generation of consolidated concerns about trafficking in the 1910s and 20s, when trafficking and prostitution overlapped in identifying and targeting deserving victims as defined by discourses of white slavery. And here, trafficking and white slavery are all in these little quotes because I think their meaning is a little bit inconsistent, subject to debate, something people are arguing about. So Ashwini Tambe writes, the League of Nations Anti-Trafficking Conventions encouraged a highly selective form of police enforcement, namely a focus on trafficking that crossed national borders and attendant neglect of trafficking within national borders and a concern only for victims with no prior history of prostitution. The League of Nations Anti-Trafficking Conventions eventually resulted in the 1949 UN Anti-Trafficking Convention, which was actually one of the first international conventions adopted by the then newly formed United Nations. India ratified this convention in 1950, obliging it to pass national legislation that would facilitate the prevention and suppression of trafficking as defined by the convention. India's Suppression of Immoral Trafficking Act, or SITA, was initially passed in 1956 as part of the Indian state's obligation under the convention and was revised again in 1986 and renamed as the Immoral Trafficking Prevention Act, or ITPA. And ITPA is what I'm going to be talking about for the rest of the paper. I'm just sort of setting up this historical context to give you a sense of where this law, which is the primary legal framework that governs prostitution in India, has originated. The use of the Contagious Diseases Acts as a foundation for the League of Nations Anti-Trafficking Convention gave rise to a legacy of conceptual and legislative connections between sex work and venereal disease, and a distinction between victims and non-victims with respect to public health interventions. This legacy was manifest in concerns about the spread of HIV in the global south during the first decade of the HIV/AIDS pandemic, and in fears of female sex workers being potential vectors for sexually transmitted diseases. Subsequently, while concerns about prostitution in Bombay persisted, along with both formal and informal policing practices in the city's red light areas, concerns about trafficking in relation to prostitution became interpolated into normative concerns about prostitution per se, concerns which focused on containing venereal disease within the bodies of sex workers, on public morality, and on managing the spectacle of prostitution in public space. The advent of HIV in the 1980s marked another moment of consolidated interest in prostitution internationally and within India. While state apparatuses and non-governmental organizations in the global north were focusing their concern about HIV on gay men, international development agencies and governments in the global south prioritized so-called heterosexual routes of transmission. The concern that migrant, which the word migrant sort of read as poor, laboring, unskilled male laborers who had sex with infected urban female sex workers would then transmit HIV to their rural, and rural should be read as innocent, unwitting wives, became the primary focus of HIV prevention efforts. So in essence, rural wives become deserving recipients of HIV prevention services, sex workers are vectors, men are the conduits between these two populations within some of the public health literature that was coming out at this time. Brothel-based sex workers in cities like Bombay were defined as potential vectors of HIV by emergent public health discourses on the issue, produced both within India and in the international public health literature. An effect of the focus on sex workers and later sexual minorities with respect to HIV in India meant that resources became available for work with sex workers and other groups marginalized on the basis of sexuality. Funds targeting populations that were considered high risk for contracting HIV were successfully won by their advocates and in many cases used to form the basis of several long-standing advocacy and service organizations that have influenced HIV/AIDS related policies internationally. As organizations in India have responded to the rising rates of HIV infection in the country, state-level concerns worldwide about the rise in cross-border human trafficking have also risen dramatically, especially over the last 10 years. Several aspects of the international trafficking discourse complicate reaching agreement on the appropriate remedy for HIV prevention, among other things, given the polarities of the debate on trafficking, particularly with respect to whether prostitution and trafficking are equivalent or even relevant terms. the illegal, illicit, and/or underground nature of the industries and service sectors into which people are trafficked, such as prostitution, and the lack of consensus on the parameters of human trafficking vex this discussion even further. These debates have complicated the call to reform the ITBA, which has been a governmental agenda item for at least a decade, and it's been spearheaded by the Ministry for Women and Child Development. While stakeholders across the board have agreed that the law needs to be amended, there has been vast disagreement on what should be reformed and why. Within the context of India's poor ranking in the US State Department's Trafficking in Persons Report, or TIP report, both governmental and non-governmental stakeholders in the process to reform ITBA tacitly acknowledged that India would clarify its commitment to ending human trafficking and improve its tier ranking in the report if newly proposed amendments to the law were passed. This was borne out by the proposed amendments themselves, which seemed to coincide with the TIP report's call for India to enact more laws and legal penalties against traffickers, and also seemed to coincide with the views of anti-trafficking activists who call for the abolition of prostitution altogether. And I can talk later in the discussion, if people would like, about what the consequences of this TIP report ranking actually are. Proposed amendments to ITBA would include criminalizing the clients of sex workers and would enable aggressive rescue and rehabilitation programs for sex workers as victims of trafficking. Both of these sets of amendments met with much criticism from Indian sex workers' organizations and HIV/AIDS advocates, who argued that the criminalization of sex workers would only impede HIV prevention efforts. An example of this argument is to be found in the subject of a 2002 Human Rights Watch report, which documented the illegal detention of public health outreach workers whose distribution of condoms was understood as proof that they were soliciting clients for sex. I'm going through these amendments sort of broadly, but I should mention that as also emblematic of the complexity and the interrelated nature of these things, all bets are sort of off with respect to this whole revision of ITBA process, because it was being spearheaded by the Home Minister, who was just fired because of his ministry's lack of capability in dealing with the attacks in Bombay on November 26th. So in some strange way, this discourse on security, national security, is now related to this other discourse on health security. ITBA has generally been used to control urban brothel-based sexual commerce. Its main clauses have served to contain visible signs of prostitution in public urban spaces, particularly through the ITBA's anti-solicitation clause. ITBA does not render the exchange of money and sexual services illegal per se. Rather, a host of activities around prostitution are illegal, including but not limited to solicitation and surviving from the earnings of a sex worker, a clause that ostensibly targets pimps but ends up also penalizing families of sex workers. Other proposed reforms include enhanced penalties for running a brothel and lowering the rank of police officers legally empowered to conduct raids on brothels, which would, of course, make raids much more frequent. The proposed amendments also include a new expanded definition of prostitution as sexual exploitation or abuse of persons for commercial purposes or for consideration in money or in any other kind. This clause effectively defines prostitution in terms of exploitation, a word that has been repeatedly used to indicate prostitution in contemporary debates on human trafficking. By defining prostitution as always and inherently exploitative, the amended bill, if passed in this form, would make any form of sexual commerce available to anti-trafficking measures that also center the problem of exploitation, and would preclude any legal or official recognition of sexual commerce as a livelihood strategy. This is significant for two reasons. First, because the argument that criminalized prostitution populations are typically harder to reach for any public health outreach efforts. And second, because it explicitly recognizes people who sell or trade sexual services more episodically and who have until now occupied a liminal and less visible legal status. This clause potentially expands the terrain on which the law can be interpreted and enforced, and would complicate efforts to form sex workers' unions, peer education groups, or advocacy organizations that do not center exploitation and criminalization in their orientation to prostitutions. The amendments would, however, address India's tip report ranking, as evidenced by the emphasis on broader parameters for criminalization in the proposed language of the reformed law. Within this legislative context, the proposed amendments to ITBA became subject of an extensive review process in 2005, following public outcry against amendments that would criminalize clients of sex workers, thereby eliminating sex workers' livelihood, as well as other amendments that would expand the definition of prostitution inordinately. The loudest critics of the amendments included a coalition of sex workers' rights and HIV/AIDS advocacy groups. The amendments were tabled in a parliamentary standing committee that received feedback from a wide array of organizations advocating on all sides of the issue. In 2006, the committee released its review of the amendments based on lobbying from organizations and its own evaluation. Two clauses of the standing committee's evaluation are notable. First, a clause stating that exploitative sex for profit should be distinguished from sex that is neither exploitative nor for profit. And second, a clause acknowledging the complexity of identifying trafficked sex workers. They write, quote, "The committee is of the view that it is a cardinal principle of criminal law that what constitutes an offense must be clear and not vague," unquote. It is significant that the Standing Committee evaluated the proposed amendments to ITBA as requiring clarification about the language, such that blanket terms would not be encoded in law. The committee also agreed that some legislative attention should be paid to non-brothel-based sex work, stating elsewhere in the document that roughly 80% of sex work in India is non-brothel-based. So to non-brothel-based sex work and why it matters in this conversation. In its 2006 baseline serosurveillance study of female sex workers, India's National AIDS Control Organization released an estimate that 20 to 30% of all prostitution in the country is brothel-based. This means roughly 70 to 80% of all prostitution in India is being assessed as non-brothel-based, and the fact that it's being assessed as non-brothel-based by a government agency begs the question of interventions. With so much sex work occurring in unorganized, episodic, informal, underground, and other non-brothel-based contexts, and sex work generating a significant portion of the incidence of HIV infection nationally, which, by the way, is 0.3% of the population of India, or around 2.4, 2.5 million people. A commensurate effort to address health and other concerns in this sector should reasonably follow. Interventions are currently underway among non-brothel-based sex workers, targeting, for example, women working along highways or in caste-based communities where female sex work is considered quote-unquote traditional, and in public markets where underground prostitution is solicited. However, much of non-brothel-based sex work still remains unaddressed. For example, women who solicit contracts for construction work from public labor markets, known as nakas, throughout cities like Bombay, and who also solicit clients for sex there, rely on their invisibility as sex workers in the law, if not in serosurveillance studies, to engage in these various livelihood strategies. Although all of the women soliciting paid work from the nakas are subject to the stigma of prostitution, the engagements of women with sexual commerce are highly varied, ranging from no engagement at all to trading sex for paid work to soliciting clients for paid sex under the guise of legitimately and legally soliciting paid construction work from the naka. So to conclude, I think naka-based sex workers, people who are soliciting kind of contracts for manual labor from these public labor markets, show, among other things, that the daily life of sex work in a major city like Bombay is much more difficult to quantify, track, and even define than the contemporary legal and policy debates indicate. Although the vast majority of health and legal interventions regarding sex work tends to focus on prostitution that is urban and brothel-based, the epidemiological data at least indicates that brothel-based sex work is only one part of the story. This ostensible contradiction may be ascribed to the historical preoccupation with limiting the visibility of prostitution rather than prostitution itself, and with the interventional accessibility of urban red light areas. The likely demise of the brothel-based system in India, as urban red light areas are displaced in favor of the real estate they occupy, also raises questions about the policy and legal framework that has been used thus far to manage prostitution as a whole. In addressing the complexities of prostitution on the ground, it may be helpful to recall another legacy of HIV in India, that of the funding streams that have institutionalized and perhaps even industrialized public health interventions. The attendant critiques of HIV-related funding and accountability with respect to the NGOization of health and education services in the Global South notwithstanding, some of the early funding was successfully leveraged to form an infrastructure of non-governmental organizations that work with a host of so-called sexual minorities, including sex workers, gay men, and men who have sex with men, or MSMs. This infrastructural development was facilitated by framing multiple interventions in terms of HIV prevention and the success of using scholarship and analysis to demonstrate the links between HIV infections and issues of social justice, which were framed as utilitarian strategy for preventing HIV transmission. Of course, this infrastructure also grew alongside an existing cadre of autonomous, non-funded, and party-affiliated organizations, and is part of a web of non-governmental organizations and social movements throughout the country. While it would be inaccurate to map didactic resistance onto these movements, the discourses on public health, prostitution, and the law they generate entail crucial critiques of the current juridical system and the ways in which this regime must and will change. Thank you very much.
Okay, the last speaker on our panel is Matthew Pierce, who is a postdoctoral fellow at the Injury Prevention Research Center at the University of North Carolina in Chapel Hill. Before coming to Chapel Hill, he worked as an assistant public defender in Baltimore City, participating in a pilot program aimed at promoting an alternative approach to public defending. His research interests include the constitutionality of gun detection technology, the use of zoning laws to combat obesity, and the legal and policy trends surrounding HIV testing of pregnant women. And today his talk is titled Opting Out of the Opt-in, Opt-out Distinction in HIV Testing. And he's actually going to be using PowerPoint slides, so the rest of the panel might want to move to sit so we can see.
Okay, good morning. And thank you for letting me talk today. So I'll actually just first get this off of my chest. So I tend to be a rule follower, and I was a little bit worried about whether I had actually followed the instructions in terms of this topic. And my fiance this morning kind of compounded my concern by mentioning that none of my PowerPoint slides even mentioned women at all. And standing up here as the only person who's not a woman made me a little nervous. So I'm going to try to explicitly tie everything in just so that I'm sure that I'm following the rules. And it's not any sort of moral motivation. I'm motivated mainly by guilt and fear of authority. So what Eugenie, when she contacted us, one of the things she asked for was how the legal categories, the categories that the law creates, how that affects public health and what impact that has on public health. And I've kind of interpreted legal broadly as policy categories, and the policy category that I'm going to be talking about, according to the title, the original title, which is no longer up there, is the opt-in, opt-out distinction, which is what the CDC heavily relies on in its latest recommendations on HIV testing. And my argument about that distinction is that I think it's problematic for sound policy debate and sound policy decision-making. And there's two reasons that I think it's problematic. One, the terms opt-in and opt-out are used inconsistently throughout the literature to the extent that, as I will show, what some people call opt-out is actually opt-in. Usually opt-in is not also opt-out, but opt-in might be another category. So that inconsistency is problematic in terms of relying on these as legal categories. The other reason is that I'm going to try to show where I think the debate is on HIV testing. And once I do that, my argument is that you can't just take that debate and divide it into two groups, two broad groups, and say, well, it's either this or that. We need a lot more precision in the way we categorize our HIV testing policies. So those are my two arguments. And to make that second argument, that's how I got this title. I'm going to be introducing a framework that I hope will help you all understand the complexity of the relationship among HIV testing policies, testing uptake, and patient autonomy. Okay, so just to start out, this is kind of housekeeping. I said that I talked about sound policy making. What I mean by sound policy making is achieving optimum levels of two desired policy outcomes. One is increasing testing uptake, and the other is protecting patient autonomy. Those are not the only outcomes that people talk about with respect to HIV testing, but they are the main ones when we're talking about consent policies. And that's what opt-in and opt-out focuses on. When I say optimum levels, what I mean is this. So you could have three different relationships between these two outcomes. They could be positively correlated, in which case we would want to maximize both of them because they're desired outcomes. They could be independent of each other, in which case we would want to maximize both of them because they're desired outcomes. Or they could be negatively correlated, as many people have argued. It's the public health lawyers love to talk about the conflict between public health and the individual. And if they are negatively correlated, then I'm just asserting here that the optimum level requires adherence to the least restrictive principle. That principle is best explained through example, I think. So if you're choosing between two policies that you say you want a 95% testing rate, you have two policies. One policy infringes more upon patient autonomy than the other. You take the one that infringes less. That's the least restrictive principle. It's not, I think it's a pretty fair assumption. Okay, so I'm going to start off actually on where there's agreement in the field as I see it. And I'm not the only one who sees this way. We can divide, one way to divide up testing policies is into 4 groups, or 5 groups, I guess. You've got client-initiated testing and counseling and provider-initiated testing and counseling. And client-initiated testing and counseling is when the clients themselves go, and it's usually at an HIV clinic, they go and they ask to be tested. Provider-initiated testing and counseling is when the provider offers a test, and that can be done in a number of different ways. It can be done just on a symptom base, so if somebody appears to be HIV positive, then the provider will offer it. It can be risk-based, so if you're in a population, you don't have any symptoms, but you have signs that you might be at risk, the provider will offer it. It can be in an antenatal setting, or it can be routine. And that would mean all patients are offered HIV testing, not necessarily every time they go to the hospital, but when the first time they see their provider, for example. So the reason, where there's agreement here is that I have not seen anyone say that any of these are bad ideas. I think there's agreement within the public health community, at least, that routine provider-initiated testing and counseling and client-initiated testing and counseling are okay in theory from a patient autonomy perspective. And I make a point to say that because if you read, and I don't recommend reading the most recent CDC recommendations, but if you want to, they spend about 90% of their rationale on saying why routine provider-initiated testing and counseling is better than risk-based provider-initiated testing and counseling. And it's just not where the debate is. And the debate, in my mind, from what I've seen, is between opt-in and opt-out, and the CDC recommendations, which you can tell I'm not a big fan of, spend about a paragraph on that debate, on why opt-out is justified over opt-in. So, as I said, these terms are defined inconsistently throughout the literature, but I'm going to give you the generalities. For opt-in, It's usually provider-initiated. Some people don't. Some people define client-initiated testing as opt-in, but usually provider-initiated. The patient must affirmatively agree to test. It's associated with it being a written agreement and comprehensive pre-test counseling. The opt-out is always provider-initiated, and that is consistent, and it's associated with testing conducted unless the patient declines, so there's no need for an affirmative agreement. One example is the New York Department of Health was recommending that doctors just say to patients, I'm going to do an HIV test on you. Do you have any questions? So that's kind of an extreme example of opt-out, where you don't have to say anything and the test will be done. And there's no requirement for written agreement specific to HIV testing. Okay. So the proponents of opt-out testing, I now have to give you a little bit of background about where the debate is. There has been a move in recent years to scale up HIV testing, and this is worldwide. This is in the United States, but it's also outside the United States. And public health is an agreement that we need to scale up HIV testing. Proponents of opt-out testing argue that this is the way to do it, by simplifying the consent procedures, getting rid of written consent, and by abbreviating the pre-test counseling, you're going to raise testing uptake. The opponents are raising concerns about patient autonomy, and so the assumption is that by abbreviating these things and getting rid of these requirements, you're reducing patient autonomy. And so, as I said, this has been framed as a classic conflict between individual rights and public health. I want to caution against that assumption with respect to HIV testing. And the reason I want to caution against that assumption is that, first, it's not clear to me that these two goals are actually in conflict. I haven't seen the evidence yet, and I'm going to go over what the evidence that the opt-out people use is, but I haven't seen the evidence for it. The second reason is that when you call it a conflict between public health and individual rights, you forget the public health that is on the other side, that is on the same side of the individual rights, and that's the public health that Jane spoke about in her talk of there are adverse public health outcomes that are associated with HIV testing: domestic violence, stigmatization, abandonment, and those public health outcomes, and the reason here I'm going to justify my presence at this symposium, is that those outcomes disproportionately affect women. And so by calling it public health versus individual rights, rather than recognizing that it's also public health versus public health, real public health concerns, you're making invisible those injuries and those public health concerns. And so I just want to caution about that. I'm not saying that public health never comes in conflict with individual rights. I think it does sometimes, but I want to caution against the easy adoption of that framework. So where's the evidence that opt-out, opt-in testing actually leads to higher testing uptake? If you look at studies, they consistently show what they call an opt-out testing method does lead to higher testing uptake than what they call an opt-in testing method. So that's one point for the opt-out proponents. What's also striking about these figures, however, is the range that you see of testing uptake within each policy. You see 25 to 83%. That's just one study. Across studies, which is not always fair, I admit, but across studies under policies that are called opt-out, you see 65% to 99.9%. And so you see overlap between at the high end of the opt-in and the low end of the opt-out. And so it suggests that, well, maybe not all these policies are the same. There's more than just two categories of policy out there. And so what I did is I read through all the studies that defined a policy as opt-out, and I looked at how they defined it. And if you look at the one that did 99.9%, and by the way, I'm a little bit concerned about a study that says that it's, respects autonomy at all, and it achieves a 99.9% testing rate. But that aside, in that study, they didn't define it as the traditional opt-out. They just defined it as women had to give verbal consent. I think even more interesting is the 92.5% that was achieved under this study, where all pregnant patients had a 1-hour visit devoted to counseling, which is a lot of pre-test counseling. That's on the long end of pre-test counseling. So we're not talking about an abbreviated counseling session. And then there was actually 2 studies in the 12 that I looked at in which written consent was required. So these actually fall into what a lot of people would call opt-in testing. And the reason I point this out is we're achieving very high rates under what is actually an opt-in, or arguably at least an opt-in, opt-out hybrid, maybe a third category. And if we can achieve the rates we want, if we can achieve that higher testing uptake without reducing autonomy, we should do that. So my concern, however, is that because we use a single term opt-out to define all these categories, we lose that nuance. And then what happens is that people like the CDC, for example, will recommend more restrictive regimes than are actually necessary to achieve the higher uptake that we want. And this was just one final study, 2008, because the other ones I could just find, there was one category in which they were different. Here, this one, 90% for children, it required pre-test counseling, and the caregiver had to give written agreement. So what I hope that showed was that there is inconsistency with the way we define the terms opt-in and opt-out. I think that's dangerous, and I don't think it's easily remedied, because the reason I don't think it's easily remedied is that even if people define within their studies or within their articles what they mean by opt-out, if you don't have people reading those articles closely enough, they're just going to read opt-out. And so you're going to have this assumption that it's these more restrictive policies that people are recommending. So what I want to do is I want to move away from thinking about all these different types of testing policies as just one or the other, and I want people to think about them with more precision. So what I did is I went through the literature and I found all the different provisions that either people have explicitly said are connected to patient autonomy, or that people have said are likely to influence uptake of testing. And I separated them out. I grouped them into different categories, and I separated them out. And I think this is at least a more precise, if somewhat cumbersome way of thinking about the HIV testing policies. So you have communication provisions within policies. So you can regulate, the policies can dictate the content of the communication and the context of the communication, which I'll go over, the means of communication, I'll go over all that, then the background rights and the implementation. The content of the communication. So you have all these different bits of information that can be communicated from the provider to the patient. They can recommend the test, they can offer the test, that can be seen as different. They can tell the provider, the patient, that testing is routine, that can have an impact. The ones that I've put in bold are all the ones that the WHO has indicated are minimally necessary for informed consent. And I can tell you, we, with a group of colleagues, went over 19 different policies from 19 different countries, and we found only 2 that in their policies that recommended that providers tell patients about the risk of testing. So that's a big one. But I think that we want to be, when we're describing a policy, aware of all these different types of provisions that can be included or excluded in any policy. On the patient to provider side, there's either a requirement that you agree or a requirement that you decline. The context of the communication is how that communication, is it written or verbal? What language is it in? Is it in the patient's preferred language or native language? What setting is it in? In antenatal settings, you have group information. And if, for example, the consent or the agreement had to be given in front of a group, that would certainly change how much autonomy was there. And then there's the relationship between the provider and the patient. Is the provider a doctor or nurse? And which one of these types of patients is it? So the way I conceive of this all would be on a three-dimensional matrix, which I don't have the graphic ability to do, but where you have basically the content of the communication on a y-axis, the means on the x-axis, and then a z-axis where you would have the relationship. And so you can imagine all those various cells in that three-dimensional matrix where policies could be differentiated. The background rights refer to the right to test, the right to decline. So these are similar to what's communicated, but they don't have to be communicated. You could have a right to decline testing, but it may not be communicated to you. And that would affect whether or not your decision is autonomous. And then finally, there's implementation concerns, and these hardly ever get talked about. But this is how the autonomy provisions that I've identified are actually how does the policy make sure that those policy provisions are actually implemented? So how do you train the counselors? How do you monitor whether they're abiding by their training and making sure that the consent procedures are followed? And these are possible ways to ensure that not just that the testing uptake is higher, but also that it's done in a way that is consistent with patient autonomy. And so my hope with all this is that when we think about all those different ways, all those different levers that we can use in the policies, in the HIV testing policies that we create, we can be a lot more subtle. And we may still find that, well, we have to infringe a little bit on patient autonomy, but we don't have to kind of, I'm forgetting the expression that Obama used over and over again, but use the hammer. You can, is it a chisel? I'm not very good with tools. Anyway, you can be a lot more subtle by being more precise in how you think about these policies. And I think that's my last slide. Thank you. I wanted to thank Suzanne and Allison who are here today, and Eugenie for organizing this, and the Duke Journal of Gender Law and Policy. Thank you.
So we have about 10 minutes for questions or comments from the audience for our panelists. Yes.
I have a question for Mr. Pierce. I was just wondering about your thoughts on pretty much mandatory HIV testing for pregnant women. I know in North Carolina the statute basically reads now, it's pretty much mandatory. So, I mean, do you think that your analysis is the same when you're talking about pregnant women versus the rest, other patients? Do you recommend opt-out, the opt-in analysis?
Well, for me, the jury's still out. If you showed me evidence that a mandatory, that a mandatory testing policy was the best way to achieve the uptake that you needed, then I could probably be convinced. But what the two concerns I have with that are, one, is it an unnecessary infringement on patient autonomy? Do we need to use a mandatory policy in order to achieve those testing uptakes? And the other concern I have is that, do we really want 100% uptake? I mean, we all agree that we want uptake in testing, but do we want everybody to be tested right away, or do we want to make sure that we're testing the right people so that they're not susceptible to the problems with testing, like domestic violence and abandonment?
about studies. I know I like how you're trying to get away from these opt-in, opt-out categories, or sort of false categories. But I wonder, even with opt-in, how much does it really do in practice to protect patient autonomy, or however you define it? Because, you know, I know when I went for prenatal testing, I didn't read all the forms. I'm sure I signed something, and then I find out later I was tested for HIV. I'm like, did I consent to that? How much does any of this really matter in practice in terms of protecting autonomy of patients?
Well, that's a really difficult question. And it's something that I didn't address, but is a very important omission, which is we don't all agree on which provisions actually protect autonomy. So there's, even if we agreed with having to, trying to maximize patient autonomy, and we agreed that it's a good goal, we might not agree with how to achieve that, but at least that would shift the debate to that question rather than these two are definitely in conflict. I don't think I've quite answered your question. I guess my sense is that you're never going to have a policy that achieves whatever autonomy, 100% autonomy for everyone. Two people who have written on this are Ruth Faden and Tom Beecham, and they have this goal of substantial autonomy. And even then, certain policies are probably going to infringe upon the substantial autonomy of certain patients. But just because the goal is never 100% achievable doesn't mean that we can't find agreement. We can at least debate those things and try to find agreement about how best to protect autonomy. And as long as we can agree that those are the goals and we need to do it in a more subtle manner than it's been done, I think I'd be satisfied with that approach.
Not to pick on Matt, but I have a question. How even beyond patient autonomy, what evidence is there that routine universal testing is actually good HIV prevention policy, that it encourages? I mean, is there actually evidence?
So I'm not as familiar with that literature as I should be. I know that the CD, I think I'm just about positive in their rationale, they say that knowing your status does affect behavior. So I know that there are studies out there that have indicated for some people that knowing your status can affect your behavior. I remember reading one, and Suzanne may be better at answering this question, and may is probably the wrong word there, that women were more likely to change their behavior upon finding that they were HIV positive than men were, so there may be difference across populations as well. But I think overall, I mean, as far as I know, the agreement is that it makes some difference. It's not the only barrier, because there's finding out your status, and there's changing your behavior, and there's being tested, and then there's finding out your status, which is happening more now because you have rapid testing. It used to be that you'd have to come back for your testing results, but finding out your status and then actually changing your behavior and taking the necessary medication. So there are those barriers, but everybody agrees that, and they may be wrong, but they all seem to agree that testing is a good thing overall, though there may be pockets, again, of susceptible people that it's not the right thing to do at that time.
I mean, my understanding was that there was some, that results lead to changes in behavior if you're positive, but not necessarily if you're found to be negative. And so I know for the group of people that I work with coming out of the criminal justice system, those people, they frequently talk about getting repeated tests, and when they're negative, that's why they continue their unsafe behavior, because they say, well, I was tested and I'm negative, and I get tested every 6 months, and so I don't have to worry about using condoms. So I don't know if there's maybe there's a trade-off. So even though they're continuing to engage in risky behavior, there's enough of a difference with those who are found to be positive and changing their behaviors that it does actually, in the end, result in greater prevention. But I was just curious.
Right. I think I haven't seen that study. I think we talked about this once before, which is if testing is actually increasing. I mean, by getting tested, it's actually increasing the likelihood that the HIV negative individuals will engage in risky behavior, that could be a real drawback, and it's one more reason to be
I
careful
don't
about
know, you
this.
might know better.
Just to add to that, that the push to expand testing is much more about the treatment now. It's not so much about the preventive health benefits. It's now we have antiretrovirals that are available and globally are available like they've never been before, but the barrier has now getting people tested. And so that's why there's this tremendous interest in testing as a gateway to treatment. So people aren't even engaging anymore in that discussion, sort of, is it an effective prevention tool? But it's really about, you have to get tested to get access to these drugs.
Other questions?
One in the back.
You have a question?
No.
Oh, sorry, I'm sorry.
I have a question for Ms. Shah. You briefly mentioned MSMs and then gay men. Is there a cultural distinction in India, or is the distinction with respect to what kind of sex work they engage in, or could you just clarify what you're talking about?
Sure, that's a great question. MSM is an invention of the public health industry. So MSM is not a term that people until recently would use to describe themselves. I think there's been this strange interaction between the public health categories and the groups that they categorize. So now there are people in India who will assert their identity as MSMs. But MSM was initially sort of invented as a way to describe men who have sex with men but don't identify as gay. And this idea being that gay as an identity and may entail practices, although the practices certainly wouldn't be uniform, like all people who identify as gay wouldn't have sex in the same way, but that people who are gay and people who are MSM may not actually be the same people. So MSM was, I think, initially supposed to describe people who either didn't identify as gay or men who had sex episodically with other men but didn't consider it as part of their sexuality. I think sex work that's done by men and by transgender people in India looks a little bit different, mainly because it's much less of the time is it brothel-based. So if you're talking about men who sell sex, then you're almost definitely talking about people who are not working out of a brothel, which has some implications that I tried to describe in the paper. The other way it's different is that men selling sex are much less iconic than women selling sex. A lot of this discourse on sex work in India and other parts of the world is really animated by the notion of a helpless woman who needs to be rescued and saved by the law. And that's definitely not the way men are positioned within this framework. So something that some researchers are trying to do is sort of kind of think about that why do we have this iconic idea of a helpless woman or girl? What happens to this picture if other people start to enter it?
Yes.
I was just going to make a note that I was just going to say the lunches are ready outside if you guys are ready to break. I had class, so I just came back. But if the panelists are hungry and everyone here is hungry, there's people outside waiting with lunches.
Okay, all right. So I'm told the lunch is sponsored by the Women's Law Association, and there's going to be a panel, which is back in here, Women in Academia. So if you get your lunch, then you can bring it back in here and hear the panel. And Janet Steverson, she has made it here from Minnesota in the snow, and so she will be talking towards the end of the lunch as well. And I'm sure our panelists, if you have other questions for either the morning or the first or the second panel, would be happy to talk with you further. Thank you.
Invite our 6 panelists down to the front of the room. Because there are 6 of you, we hope that you'll feel free to continue to eat your lunch as the other panelists are speaking. I know it's a bit awkward, but we like to try to be efficient and get everything done at the same time here at Duke Law School. I haven't prepared any remarks to introduce Chola to you today, who will be moderating this discussion. But she is one of in my impression, the most outstanding 2L law students we have at Duke Law School. So I'm very, very pleased that she'll be speaking with you today. So panelists, please come on down, and Chola, the mic is yours.
Thanks. So while the panelists are coming down and settling themselves in front, I will actually just introduce myself to you. So I am co-chair of the Women Law Students Association, WLSA, and we've done a lot of programming this year, and we were very excited when the Gender Journal contacted us to co-sponsor this lunch because we love doing career-related events. And a little plug for us, our elections are coming up on the 25th. So if you have gone to a lot of WLSA events this year and you want to take a more active role in the organization next year, we encourage you to run and email me if you have questions. So if you ladies are ready to go. So do we want to start with you or you? Who's ready? We can start with.
What would you like us to do?
I think what we'll do is if you all will introduce yourselves first and give a brief, maybe 3 minutes or so, background on your careers, and then we'll open it up to questions. And if you all are too shy to talk at first, we have the prepared questions we'll delve into.
Okay.
All right?
Okay, I'll start. My name is Deborah German. I am a physician, rheumatologist, and I started my career at Harvard Medical School, did my internal medicine in Rochester, my residency training in rheumatic and genetic diseases here at Duke, and started my career here and became an associate dean here. Did some work at Vanderbilt and became a hospital chief executive officer, and I'm now in Central Florida building a brand new medical school as part of a medical city at the University of Central Florida. And I guess that all pales by comparison to one little thing on my resume that's very important right here, and she's shaking her head and saying no. But I happen to be Julia German's mom, and
She forbade me from asking you any questions about her during the panel.
she'll find herself woven into answers somehow. But anyway.
Thank you.
I'm Jeanette Schreiber. My background is that I started out in social work and have a master's in social work, and then decided to go to law school to pursue law that relates to human services. Became a healthcare lawyer in 1982 when health law was just getting invented. And I worked through a New England law firm for 24 years in health law, which is a really fun area. It's an industry-based practice, so you work on a wide variety of types of areas of law representing, in my case, mostly healthcare providers. So I got to work in legislative and policy and a lot in the development of programs and services and work as a team with the clinicians, and then work on each wave of activity that came through healthcare over those years, so ranging from issues of informed consent and unplugging the respirator to mergers and acquisitions and HIPAA and reimbursement. So it's really a lot of fun. And then, so after 24 years of that, I wanted to go home to Central Florida and did that and got to meet Dr. German. And now I'm part of her team building the College of Medicine.
I'm Maya Manion. I think I was one of those people who went to law school mostly because I didn't know what else I wanted to do with my life, and it was a good way to put it off for 3 years. But I had some vague notions of wanting to do something with women's rights work. And so after law school, I sort of did everything under the sun as a practitioner, public interest, government, private sector, before I went into academia. I spent a year in India as a Fulbright scholar, traveling around and also researching domestic violence laws. I clerked on the Ninth Circuit. I did a one-year public interest fellowship at the Center for Reproductive Rights, doing mostly abortion rights litigation around the country. Then I went to a firm to make some money for a change and pay off some debt. And then I went to the California Attorney General's office, where I was actually mostly working on prisoner civil rights litigation before I finally went into academia. And I did have some notions of maybe wanting to be a law professor in law school. So I tried to do things in law school that would help me on that path down the road. But I bounced around a lot trying to figure out what I actually wanted to do, what sector I wanted to be in, whether I really did want to become a professor. So it was some planning and a lot of haphazard random luck as well that determined my career path.
Mine was all haphazard.
So I'm Michelle Oberman, and I went to law school in the mid-'80s at Michigan, and I really hated it, and so I dropped out after my first year. The only thing I had liked before law school was my work at Planned Parenthood doing pregnancy tests, and so I figured I would do that for a living, but then when I realized that I'd just been volunteering to do that, but it wasn't exactly going to be a living, and so I went overseas for a year and did sort of a Peace Corps kind of program, learned Spanish, which was great, met a lot of women who are activists in women's health who pretty quickly said, get back to law school because you're not going to be able to change anything unless you have some power and a seat at the table. So I went back and I did a public health degree along with my law degree, which was a way of keeping myself sane because people in public health school were just lovely classmates. They were really great to be around. They were worldly and really very balanced. And so I managed to do a law degree and a public health degree at a time when AIDS was just hitting Michigan. So I actually also cut my teeth on AIDS work. I was hired at minimum wage by the Department of Public Health to rewrite the public health code as a staffer. And I got to work with a bipartisan committee that was just, aiming to rewrite this completely out-of-date public health code and then pass it through the legislature, which eventually it did. And then I graduated law school. Under my gown, I had on cutoffs and a T-shirt. I was the only student in my class who didn't have a job. It was the late 80s. The market was booming. The firms were lining up. And the only thing I knew was that I didn't want to be a lawyer who had to wear a suit. And so given my credentials and the fact that health law was new, I was able to land a job in Chicago at this Institute for Health Law. And I never would have been picked as a usual subject for a law professorship, but they stuck me in a classroom anyways, and I loved it, and I never wanted to leave because teaching is a blast. I would pay to do it, and the only reason they pay us is to grade, I think, which is really a drag. And that's sort of that's the way I ended up doing what I've been doing.
Hi, I'm Jane Stoever, and really, I grew up in a family that was really focused on social justice issues. So going to missile silo protests and spending a lot of time in homeless shelters and things of that nature were just part of our regular family conversation in life. And some of the things that I loved was just sitting with people, listening to their stories. And I later was a live-in staff member at a homeless shelter before coming to law school, and also worked at a shelter for teenage girls. And you so quickly, in talking to people, recognize all these legal issues. And so that's what really drove me to want to go to law school. And during law school, for the last 2 years of law school, I had similar feelings. First year of, wow, this is really weird to be focused on casebooks all the time when I really actually just like interacting with people. And it's strange to think about having this great importance on your own responses in class all of a sudden and on yourself when you really are used to working out in the world. And so my second and third years of law school, I was a student attorney with the Harvard Legal Aid Bureau, and I just threw myself into that, where for 20 hours a week I'm representing, it turned out all of my clients had experienced domestic violence, which I learned in the course of the representation, but representing people in family law, housing, and public benefits cases. And I also did legal services work during my summers. And so I came to law school wanting to do legal aid work, thought I would do it following law school, and never thought I would be in a law school where I've actually never left, as it turned out, essentially. But after clerking for a year, then I was applying for different fellowships, and one of the fellowships that I applied for was Women's Law and Public Policy Fellowship in the Georgetown Graduate Teaching Fellowship in their domestic violence clinic. And I thought that this would be an amazing way to actually I would have my own clients, so get to develop my own litigation skills, but also the significance, bless you, of clinic to me in my law school education. That was my favorite part of it, to be able to share those experiences and work with students was also really, really appealing. And so I found that I also loved being in the classroom and loved just being engaged both with the client work and with students. And so after the Georgetown program, which was an LLM program, then began teaching at American University, teaching their domestic violence clinic and family law and domestic violence law, and finding it just a real privilege to still work in the world where you have all these challenges and joys, and also with students who I'm able to talk with them and help them figure out how they want to be as a lawyer and be really reflective about the lawyering that they're doing and the really important work, with our clinic focusing on protection orders, and then half of our cases are immigration cases. So a wide range of skills and work there.
Hi, sorry I just got here. Got stuck in Minnesota. A great snowstorm. And then I come here and I'm slightly hot because it was negative something in Minnesota. Anyhow, my name is Janet Steverson, and I'm a professor at Lewis and Clark Law School. And I think I took probably a more traditional route to being an academic. Went to law school straight out of college, not really knowing what it was that I wanted to do, but never thinking that I wanted to teach. And being at Harvard Law School did not make me change my mind about teaching, because I didn't want to teach there. But what I did as a second and third year was Board of Student Advisors, which is an orientation group, and then you also do the legal research and writing, because back then, this was 1984, 1985, professors did not deign to teach such mundane things as legal writing and research. And we also did the moot court competition. And I loved that. I really liked that, the teaching part of it and helping students. But I didn't feel that I could do that at a place like Harvard. So I went and I practiced in DC, you know, traditional corporate law firm, pay off the loans, get in, get out kind of thing. And then my mentor there sent around a memo saying that Washington and Lee was looking for professors. So I went and visited Washington and Lee, and it was a totally different kind of law school. I sat in on a family law class, and for the first time ever, I had the desire to raise my hand several times during the course of that class. And I thought, well, if I could teach like that, I would love to teach. So I went on the market and I found a school where I could teach like that. I love it. I've been doing it almost 19 years now, and it's the best thing in the world. And then having time for scholarship. You know, my kids are older, so I'm spending more time doing scholarship, because when your kids are little, forget about it. And that part is also fascinating and rewarding. And just, it's hard to find the balance, because I spend a lot of time mentoring students and counseling students, because I really enjoy that aspect of it. So that's how I got into it.
All right, thank you all very much. So I wanted to make sure everyone in the audience gets a chance to get their questions answered first. So does anyone have any pressing concerns before we go into our set of questions? No? Going once, going twice? Okay, so we'll start with question number one. So, not buck the trend. So, because a lot of you are in academics, we were wondering, obviously, we know that you need to have great grades in order to get a job as a professor, but what other qualities are really important? And also, I would add to that, what do you recommend we do to get on that track now in law school, if we're interested in doing that in our futures? So we can start with you, Dr. German, if you want.
Well, okay. Can everybody hear me? Okay. I think the most important thing, if you're interested in academics, is to have an open mind. You have to be a person who wants to look for possibilities. Some people go into, and of course I realize as I look down the table that I am the only physician here, everyone else is lawyers, and I'm speaking to a bunch of law students. So I hope that what I say is relevant, and maybe I'll just take this a little off track for a minute to offer what I have, and then the others may be more relevant. But for me, more than going into academics, because I think what we all share is the desire to make a difference in the world. And we all want to make a difference in different ways, and some make the difference through academics. And when I think about academics, and I've been there, when I was here, I was in the Howard Hughes Medical Institute doing research in adenosine metabolism. But when you're in academics, you're a leader, you make a difference, you're a thought leader. And I heard in a couple of the panels this morning a little frustration with being able to present ideas and telling stories and consolidating them and publishing them, but then not being able to make a difference. Or sometimes it's even frustrating to say, how can we change this thing that we've studied? So I guess I'd like to differentiate between thought leadership and other kinds of leadership. And for me, I started out as an academic, and then I had children, and I thought, you know, right now the most important thing in my life is my family. I want to keep working so that when my children are grown, I can work. But I don't know that I want to completely put my children on the back burner. So I took a different course. I left the research course, and I was in here an associate dean and program director in a residency program, did some things like that. And oddly enough, my children took me in a direction that I think was more productive. By leaving the research and doing these other things, I began to see a different world and realized there's thought leadership, there's the nurturing kind of leadership that happens in student affairs. And then other things happened, and I had the opportunity to become the chief executive officer of a hospital, and to take a hospital that was losing $2 million a month and turn it around so that it was making $2 million a month. And that takes a huge amount of effort and really a kind of love and concern for your patients. But that put me into the real world. I wasn't anymore working on the students and working on the new leadership in creating knowledge, but actually making a difference, keeping it a community asset from going under. And that was a wonderful experience that then led to other experiences. And I'm just going to jump forward. You know, one of the questions is, some of you won't work in the public sector, and advice to you about making a difference. You can make a difference wherever you are. And from my personal point of view, if you really want to change things, the best way to do that is to try to gather experience in many areas, academic, non-academic, and it will give you a vantage point that so few people have. And when we give our presentation, the last symposium, some of this will seep into it. But always have an open mind and be ready for what's coming down the pike. And I heard that again in several of the introductions when people said they didn't plan their future, it just kind of emerged. It was haphazard, and I think that's necessary.
Great, thank you.
Well, I'm going to follow Hurley and answer whichever question I want to answer here.
Go for it.
and because I could not possibly call myself an academic, since I spent most of my career in a law firm. I do happen to work for a university now, but I don't think I could hold myself to the standard of being an academic at the moment.
She's an associate dean.
I am an associate dean, but I want to both honor the value and critical importance of academics and the kind of focus that comes with being an academic, and then also honor the value of the very practical kind of work that is done in the way that we'll talk about in the last part of the symposium. And I want to kind of echo and elaborate on something Dr. German said about how you can add value in any kind of position that you're in, and to remember that in every aspect of our world, in business and government, we need people that have a strong value system and a strong ethics. And so don't shortchange yourself based on whatever you're going to do. And I can tell you from experience that there are many, many ways while you're working for a law firm to use the resources of the law firm to add value, not only in pro bono work. Pro bono work is kind of narrowly defined by law firms and by the bar as being specifically services to the indigent, and that's very important. But the kind of service you can do to your community by serving on community boards, you could run for local office and be on the school board. there are just so many ways that you can have a positive impact on your world, no matter what you're doing. That's the most important message that I had for you all.
I mean, I definitely got this message in law school too, that the only people who can be professors are the gunners, the top grades, the law review, the appellate court clerkship. And there's certainly a lot of places that do look at those credentials, that you'll have an advantage if you have those credentials. There's no question about that. These days, there are more and more people looking for interdisciplinary work, and so people with a JD and a PhD. So there's definitely this hang up about credentials, but I don't think that it's at all true that if you don't have those credentials, you can't be a law professor, that you should just shut that door. I think actually the most important credential is publications. If you're a good writer, if you like writing, you have ideas that you want to share, you can be a law professor. Even if you weren't on law review, even if you didn't have the top grades and you didn't do the top clerkships, that door is still open for you as long as you publish. That, I think, is actually the biggest factor. So if you like publishing and you love teaching or you want to teach, I wouldn't close that door for yourself, and take your time in law school, even if you're not getting the top grades, et cetera, to publish, to write, and squeeze time in for that after law school as well. And I know people who are not from top schools, didn't have top grades, didn't do law review, didn't do the top clerkships, who are professors now because they published. And in the long run, they do they have to make a sacrifice initially. They may not get the location that they want. You may have to be in a less popular city or more rural location. They may not be at their school of their first choice. But a lot of people move around in the long run. And so you might have to start off somewhere that's not your first choice, but you will be able to move to a better place as you get more senior in your career and prove yourself as a scholar. Mainly. So if you think you're interested in this, I'd really encourage you to try and forget about the hang-ups on credentials, and focus on writing and publishing to keep that option open for you, because it's a great job. I mean, I've done everything, and this is by far the best job. I feel like I won the lottery getting this job, so it's great.
So I'm going to answer it out of my past 2 years in which I served as chair of our hiring committee. So I can talk about that rather than my own completely serendipitous route into it, which clearly would not be replicable. So it strikes me that the single most important trait is passion, and you can't read passion from a resume. So you have to first of all do the internal barometer check and figure out if you actually have a burning passion for ideas. Because if you don't, then it's just not going to work. And by ideas, it can be anything, but it's this internal sense that you have something that you want to share, right? Whether it's that you learn something and immediately want to communicate it, or whether it's that you already feel like you know something that's just not being heard. If you don't have that passion, you are not going to be happy with the second thing that actually causes law professors to fail, which is solitude. It's a strangely solitary job. I mean, there's these moments of intense socialness, whether you're mentoring students, whether it's office hours, whether it's a performance in front of a class, which is largely a performative activity. But there's also a lot of time alone with your ideas. And if you're not comfortable being alone in your head, then it's probably not the right profession for you, because increasingly it is a profession of scholars. We're looking for people that aren't tenure risks. No faculty wants to go through the misery of befriending somebody, becoming close over the course of 5 or 6 years, and then realizing they don't have any ideas. Right? They don't really want to write. They're great teachers, but whatever it is these days that we think of as the currency of what makes an academic, it's people that are participating in the community of ideas. So it's not enough to be a great teacher. We'll hire you as an adjunct if you're a great teacher, but if you're not out there with your ideas, and at least at my school with a desire to serve, public service is equally important at Santa Clara, then you're just not going to make it onto my radar. And once you're on my radar, so that you've got enough credentials going for you, which really does take the writing, then the passion will carry you through. And really, in terms of those credentials, I couldn't agree more with what Maya said, that it's not the law review or the clerkship, it's what you've written, and it's who your mentors are. And so the process of law school, I hope it's not too late to give you this news, is one of finding people who you like and who you want to be like. right? And it's not too late after law school, really, but find yourself mentors, have them work with you in honing your ideas, sharpening your writing, find your passion. If it's outside of law school, great. The world needs people with passion everywhere, right? If it happens to be in the academy, great. Make sure that you're okay with being alone with your ideas, and then find yourself a community of people to help you hone your writing, and you'll be golden.
All right, thanks. And I want to bounce off of a few things that Michelle said in terms of where do you get ideas from? So the things that you guys are doing in terms of the student organizations, journals, and all the clinics that are offered here will give you all these great places to be able to start thinking about new things. And so I encourage you to take advantage of everything that's offered here in this school. And then as you go out into practice, many more opportunities for volunteering, whether it's through pro bono cases or through the local bar and different volunteering projects where maybe you're not taking on all the responsibility for one case, but a 3-hour advice and referral clinic that you're doing, where suddenly you're seeing all of these legal problems in ways that the law is not really addressing situations, and you get ideas for something that you're then passionate about and driven, and then you want to write about it. So certainly keep searching for things that you're really motivated by and enthusiastic about, and see where that takes you. And also what qualities you appreciate in an educator. And I think we think so much about the scholarship, and that's a tangible thing that is essential. But also, students appreciate good teaching, and you look to your colleagues for new teaching ideas and influences. And so being able to talk to each other right now, just among your law school peers, well, why do we like this person so much? What makes this person a really effective educator? And to take those traits with you as you go forward.
I guess what I would add, because I just served on our appointments committee, and there is certainly a trend towards already having published, already having scholarship. There are members of the old guard, and I'm part of that old guard, that resist that, and I know that there are other law schools out there that resist the desire to already have, to have somebody who's already published. Now, that said, there is, you have to have ideas, you have to have passion, you have to want to write, because you can't get tenure at most law schools unless you do write. It doesn't have to be traditional type writing, but you do need to write. But I guess what I want to say is, if you have passion about teaching and you have passion about writing and you want to go into academics, don't let the field define you. You decide where you want to be and what you want to do. We're all kind of A-type individuals, and so we all are looking for outward manifestations that I am a success. And that does not necessarily translate into a happy life. So you need to be really careful and say, where do I want to be and why do I want to be there? So when I looked at law schools, I think I did about 37 half-hour interviews at the meat market. And I did 11 flyouts because I wanted to see what was out there and to decide where I wanted to be and what I wanted to do. And I chose Lewis and Clark because, number one, they value teaching. There weren't all that many that did, in fact, value teaching. In fact, you couldn't get tenure unless you could teach. They also valued scholarship, and you never had to worry about, to whom am I going to give this piece? Because everybody was there to support you. They wanted you to succeed. So look for a place where you will enjoy what it is that you are doing. Resist the temptation to climb the ladder simply because it's there. Now, if you want to climb the ladder, more power to you. You know, I can talk to you afterwards about all the different steps that you have to go through in order to climb that ladder. And you do need the judicial clerkship, and you do need to have a published agenda. I suggest, however, that you will be miserable Okay, so be careful about that. And that's my advice to you. Find your passion, but find where you want to be.
Okay, thank you.